So I'm Romany Webb. I'm based at the Sabin Center for Climate Change Law at Columbia University. And as Diane said, I am given the easy job of summarizing the entire international legal landscape for marine carbon dioxide removal in 8 to 10 minutes. We will see how we go. I want to start by pointing out that the existing framework at the international level is very highly fragmented. There are a large number of international agreements that are potentially relevant to marine carbon dioxide removal. This slide shows some, but by no means all of them. There is still a degree of uncertainty as to how these different agreements apply to different MCDR techniques, and also how they intersect and relate to each other. And so one reason for that is that none of these agreements were actually intended to govern marine carbon dioxide removal. In fact, most of them were adopted many years, and in some cases decades, before marine CDR began to be widely discussed as a potential climate solution. Recently, the parties to some of these agreements have begun to consider marine CDR and think about how it fits within these existing frameworks and how those frameworks might need to adapt to these new activities. So I want to spend a few minutes now talking about some of the recent actions that have been taken and some of what might happen next. So I'm going to start with the agreements that make up the global climate change regime. If we look at the United Nations Framework Convention on Climate Change, the UNFCCC, which is really the foundation of that regime, we see there actually quite a degree of support for carbon dioxide removal. So you can see on the slide, the UNFCCC talks about parties mitigating climate change, not only by reducing their greenhouse gas emissions, but also by protecting and enhancing greenhouse gas sinks. And the definition of sink is very broad, encompassing any activity that removes a greenhouse gas from the atmosphere. So we see this support within the UNFCCC for carbon dioxide removal, and that support has only grown in recent years. We see similar language in the Paris Agreement, which again reiterates the need to protect and enhance sinks, and it talks specifically about removals via sinks being used to counterbalance residual emissions so that we can get to net zero. Now, at the time these agreements were adopted, the focus was really on terrestrial sinks, and there was a heavy focus on forestry in particular. But over time, we've seen a growing recognition of the importance of marine sinks. And so recently, the parties to the Paris Agreement have adopted a number of statements and resolutions that emphasize the need to protect and enhance marine sinks. And we see a growing number of countries incorporating those sorts of actions targeting marine sinks into the nationally determined contributions, the NDCs, that they submit under the Paris Agreement. Now, to date, the focus has been on these so-called nature-based solutions, sort of the coastal blue carbon type solutions. We are yet to see more novel marine CDR approaches like OAE be incorporated into countries' NDCs. In part, that's because there are no established methodologies for estimating and reporting on removals via those novel techniques. As I think you'll hear about on the panel, there is an ongoing effort by the Intergovernmental Panel on Climate Change to develop those methodologies. But there again, the focus is very much on terrestrial systems. We have also seen within the climate change regime an effort to integrate carbon removal into trading mechanisms. I don't have a lot of time to get into this, but very simply, there are two basic trading mechanisms set out in Article 6 of the Paris Agreement. The first, in Article 6.2, provides for country-to-country trading of what are called ITMOs, internationally transferred mitigation outcomes. So the basic idea is that, a country that's on track to exceed its NDC goals could transfer ITMOs to another country, and that second country could then use them to meet their own NDC goal. We actually saw the first ITMO trade involving a carbon removal project agreed to last year between Switzerland and Norway. This is a project that involves bioenergy with carbon capture and storage. Interestingly, the storage is to occur offshore in subsea bed geologic formations, so a little bit of an ocean link there. We also have in the Paris Agreement the Article 6 trading mechanism, known as the Paris Agreement crediting mechanism, which at a very high level is sort of a centralized mechanism for trading carbon credits that's overseen by the UNFCCC. There again, there has been an effort to integrate removals, some important standards developed and adopted by the Paris Agreement Crediting Mechanism Supervisory Body a couple of years ago, but still more work to do to actually sort of operationalize that. Alongside this work within the global climate change regime, MCDR has also received attention in other international treaty regimes, particularly those dealing with protection and management of the ocean. And so we've already heard a couple of times today about the London Convention and Protocol, where a lot of work on marine carbon dioxide removal has already occurred. For those who may be less familiar with the London Convention and Protocol, these are two separate but related international agreements that aim to control marine pollution due to dumping. And you can see dumping is defined quite broadly to include any deliberate disposal at sea of waste or other matter from vessels, aircraft, platforms, and other structures. Over the last actually 20 years, the parties to the London Convention and Protocol have been exploring sort of when different MCDR approaches might qualify as dumping, and more generally, how that regime should apply to these sorts of activities. For those of you who are less familiar with the history here, the parties initially focused on ocean fertilization, and that's because their early discussions were prompted by a proposal by a US-based company to conduct an ocean fertilization project off the coast of the Galapagos Islands. That project actually didn't go forward, it couldn't be financed, but it's really what prompted the parties to this regime to look at this topic. And that's something we've seen a lot in this regime. It has been very, I would say, reactive to external events. So in response to this proposal, the parties to the London Convention and London Protocol issued a non-binding resolution in 2008. There they said that ocean fertilization falls within the scope of the London Convention and Protocol, and they sought to provide some guidance on when ocean fertilization might be allowed. They said very basically that some limited research projects may take place, but that deployment should be deferred given the risks that it presents. In 2010, there was some follow-up activity with the adoption of an assessment framework for evaluating proposed research projects. After that, we had another, in this case, project that went ahead off the west coast of Canada, an unsanctioned ocean fertilization project, and that prompted the parties to again look at this issue. And so in 2013, an amendment was adopted to the London Protocol that's intended to address certain marine geoengineering activities. Currently, it only applies to ocean fertilization, and it effectively codifies the approach set out in the 2008 resolution. So allow some research, but not deployment at the current time. Now this amendment, while it was adopted in 2013, it is still yet to enter into force. For that to happen, it has to be ratified by 2/3 of the 56 parties to the London Protocol. And so far, only 9 countries have ratified the amendment. So there's still quite a ways to go. Why that is, why the parties have been so slow to ratify the 2013 amendment has been the subject of some discussion recently. The parties have also been thinking about what they should do about other MCDR approaches. So in 2022, they selected 2 MCDR approaches for what they described as priority evaluation. These were OAE and biomass cultivation and sinking. In 2023, they issued an initial non-binding statement in which they basically said that they think these approaches should be treated similarly to ocean fertilization, so allow some research but defer deployment for the current time. And there's since been a process to develop assessment frameworks for proposed activities. This work is ongoing, and there are many, I would say, significant questions that the parties are either beginning to grapple with or will soon need to grapple with. Some of them relate, as I said, to the 2013 amendment. Why has it not entered into force? And what does this sort of slow pace of ratification of that amendment mean for future action? You know, should the parties just double down on this approach and try to get it in force? Or does the fact that it hasn't entered into force in 13 years suggest that a new approach is needed? Also, there's questions about, you know, to date, the parties have been very focused on establishing rules for research. When and how might they think about creating a pathway towards deployment? So lots of unresolved questions there. Separate from the London Convention and Protocol, we've also seen MCDR discussed in other under other international environmental agreements, including the Convention on Biological Diversity, the United Nations Convention on the Law of the Sea, and the OSPAR Convention. By and large, these other treaty bodies have largely deferred to the London Convention and Protocol, which is very much seen as taking the lead in this space. But interestingly, for example, the parties to the Convention on Biological Diversity have recently sort of started to pay more attention to MCDR again, and it may be that we see that regime or another one play a larger role in governing these activities, particularly if progress under the London Convention and Protocol continues to be slow. Just quickly, the other thing that could be quite important and significant here is the new BB&J agreement, the agreement on the conservation and sustainable use of marine biological diversity in areas beyond national jurisdiction. That agreement was adopted in 2023 after nearly 20 years of negotiation. MCDR was actually discussed during the negotiations, and there were some proposals to include specific language on MCDR in the BB&J agreement. That ultimately didn't happen, but there are several provisions of the BB&J that could apply to or have implications for MCDR activities, not only on the high seas, but actually also in countries' jurisdictional waters. A lot will depend, though, on how that agreement is implemented and operationalized, which is still to a degree an open question because the agreement only entered into force in January, and they haven't even had the first conference of the parties yet. I'm going to leave it there, but look forward to hearing the panel answer the many unanswered questions that I flagged.